Supplementary list for pronouncement of judgment, item 38.
Read petition aloud.
Adjournment request, if any, from item number 1 to 8.
Lordship, may I please? I beg, with the consent from other side, I beg to mention item number 1. The council, the engaged council, he will not be able to present today because of sudden cardiac arrest of his father. He has to be out of station for treatment of his father. Therefore, Lordship, matter may be adjourned for today and fixed for any date in next week.
Madam, in this matter, only you are required to ascertain that whether the payment of pension is made to this arrears of the payment has been paid to
He
the
could-
petitioner or not.
The council couldn't follow up because of this sudden cardiac arrest of his father. But by next week, he will definitely do this.
He requested me for 1 week time, my lord. Yesterday he called me with 1 week time maybe granted, but till today, my lord, payment has not been made.
Payment,
Appearing for the consent for the respondent submitted that the council appearing for the department. Mr. Chaudhary is appearing.
no, H.
No,
Pura-
as Pura Gohai, Rishikesh Pura Gohai.
Mr.
For the
H-
bank, he was appearing.
Mr. H. Puragaon is engaged on account of medical emergency of his father and therefore matter may be adjourned. Let's start ready.
7, 8.
May it please your lordship, I beg to mention item 3, lordship, we had submitted an adjournment slip. We are seeking 2 weeks' time, lordship, to file an affidavit.
Adjourned for 2 weeks at the request of land council for the respondents.
Adjournment request from item number 9 to 18. From item number 19 to 33.
My lord, with your lordship's indulgence, I beg to mention item 22, my lord. I am appearing for the respondent.
Yeah,
My lord, your lordships heard the similar matter, that is the writ appeal 215 of 2024, which came on 17/6, 17/7.
what's the matter about?
And my lord, it's a matter, my lord, we have been regularized. We have been working for 18 years and 30 years,
Your teachers.
my lord.
And
Now,
the
your
similar, on the basis of the very said judgment, this, yes, last time the council was asked.
My lord, I have intimated the other side that I'll be praying for time to fix up the matter along with the other writ appeal.
What was the date in that?
There's a writ appeal number 215 of 2020. My lord, it came on 17/7, your lordship fixed after 2 weeks.
2 weeks.
My lord, I.
The council for the appellant was to satisfy that this liability of the school was not passed under.
Exactly, yes, exactly. My,
List along with number, list along with so and so.
I'm for the appellant.
You are for the appellant. You, who appeared on that day on behalf of the appellant?
In that case, my lord, there is another set of counsel, Mr. A. Sharma appeared. Mr. A. Sharma.
The same authority.
My case is a little bit different, my lord, the fact that the consent was a little bit different.
Learned single judge has relied upon the earlier judgment and passed the.
yes, yes,
I thought, sir,
Okay, list along with.
obliged.
My lord, I will mention item number 21, my lord. My lord, matter may adjourn today, my lord.
You are for the,
Appeal and my lord. Already, my lord, consent to the other side, my lord. Lord, next Monday, my lord.
adjourn.
May I please, your lordship? Lordship, with the consent of other side, lordship, I beg to mention for item number 33 of Delhi list. Lordship, kindly adjourn the matter for that day and fix it after few weeks, lordship.
You are for the
Respondent,
hearing
Lordship.
matter.
I am on behalf of Mr. Yamio Mandal.
Hearing matter.
Yes, Lordship.
Hearing matter. my lord. Adjourn. Yes.
Lordship, I beg to mention, my lord, item number 35, hearing matter. Matter relates to pension, my lord. Pension already been released, my lord, and there is no any further grievance. So ultimately matter is infectious, my lord.
And concept of the petitioner on instructions has submitted that the relief paid for. The relief has already been granted to the appellant. You are for the appellant,
Appellant, my lord.
therefore, this writ appeal has become infectious, dismissed as infectious.
Lordship, high lord.
Lordship, with the consent of the other side, I beg to mention item number 36, Lordship.
Yeah.
EYJ is out of station, matter may be fixed next week.
Adjourn.
With the consent of the other side, I beg to mention item 34 of today's daily list. Lordship, in this matter, I appear for the respondent. Lordship, it relates to a departmental proceeding. There were certain bank transactions involved in this matter, Lordship. With regard to those, I need some instructions. Lordship. So it may be taken up after 2 weeks.
Adjourn,
Lordship.
adjourn. The hearing matters will go after 6, 7, 8 weeks. If you are not ready to argue the matter, it's okay. Yes,
Lordship, I beg to mention item number 37, which was fixed for hearing today. Uh,
yeah,
the matter may be adjourned for today and for
Yeah,
fixed for next week.
okay.
I'm for that.
Please, your lordship.
Highly obliged.
I beg to mention for listing of the material, urgent matter, pension matter, your lordship. Matter will list on the next, 1st August, your lordship.
Next week. Is it old matter or new matter?
My only matter, your lordship, 157. Read it.
Next week.
Master. Any other request?
Please, my lordship, I beg to mention for listing a matter of writ appeal.
Writ appeal, what's the urgency?
The lordship has that contempt case is pending on before the honorable single judge.
When it was listed last?
It was listed on last on 25th, lordship, 25th of July or June.
Then what was the next date fixed?
It has been said by lordship that after 3 weeks, but it's more than 3 weeks.
It's get it checked.
Can this matter be fixed on 31st?
Certainly, the registry might have fixed some date. After 3 weeks, so it's not that it's a matter for sine die, urgent for sine die. Must have fixed the date. Have you checked with the registry?
Yes.
What was the date fixed? What is the date
No,
fixed?
date was not fixed.
Can't be. Let it check.
Registry. For orders, item 2.
Make these lordships. Plus, in terms of the last order, we had made the paper publication on 23rd of June, my lords. Plus, the affidavit was filed yesterday, but it is not on record. I have got extra copies of the affidavit, my lords.
Office man paper.
We have made the paper.
Where is that?
I got extra copies of the affidavit. Plus, we'll find it at page number 4 of that affidavit.
An affidavit is filed on behalf of the council person. Appellant. Stating that the notices upon the unserved respondents has already been served through paper publication. A copy of the newspaper in which the notice is published is placed on record along with the affidavit. Stop. In view of the above, the service upon the respondents be treated as complete. Just after 2 weeks for admission.
Item 4.
May I please? Your Lord?
Yeah,
Lordship, representation was filed on 27/6 in pursuance of earlier order, Lordship.
you have already approached the director.
Secretary,
Yeah,
yes, Lordship.
you have, where is that?
We have filed affidavit, Lordship, on 16/7, Lordship. Annex
16/7
annexing the representation, Lordship.
is not available on record. It is there. Yes, it is there. Who is appearing for the respondents?
Last provision, Mr. N.J. Khatunia repair, Lordship. Name is reflected, Lordship.
It will be passed over. After some time, we'll take it.
Item number 5.
Lordship, from the GMDS affidavit, if Lordship is pleased to come to paragraph 6. Yes, TPU construction work is going on, 65% is
Just,
completed. Paragraph 6 of the GMDS affidavit,
just a minute.
Lordship.
Yeah.
By what time
Uh,
you're going to complete this?
By October, Lordship.
October.
Now it is 70, although at the time of filing affidavit, it was 65. Today we have taken the instruction 70% over. By October, we are commissioning the sewerage treatment plant, Lordship.
No, my lord, main issue was, my lord, enforcement of that water reserve, water body, my lord. That in 2001, they declared is a water body. But now large scale enforcement is going on. That's why, my lord, GMC was asked to file affidavit. But till now, GMC has not filed anything.
That encroachment we have cleared. There was another case, Lordship, where we have removed that person, giving him an alternate. We could not give him alternate place, so 78 lakhs rupees, Lordship. Remembers their case was,
That is in relation to that.
yes, Lordship.
This very.
Yes, Lordship.
So only.
Only thing is that there is a garbage transfer station there. If 60% of his land, we are trying to find an alternate location where we are going to shift this garbage transfer. To that effect, because we did not file the affidavit, because Lordship, that final area we could not demarcate where we are going to shift. The process is on, within 10-15 days, we will find an alternate place and we'll come out.
So only that encroachment is there, other encroachment?
That encroachment also we have cleared, Lordship. So far as the garbage station is concerned, otherwise there is no encroachment.
Yes, Mr. Mehta.
My lord.
In the petition also, there is no such.
No, my lord,
In the
that is
letter
that
also
is the
there is
main
no
issue, my
indication.
lord, regarding the enforcement. But regarding enforcement, my lord, they have not said anything. GMC has not filed affidavit, my lord.
Now,
No, no.
Advocate General is making a statement that except one, that garbage area,
My lord.
all the encroachments have been removed. Whether you file any counter to it or it's it.
That, my lord, yes, that is a statement may be favored to Honorable Court. There is no affidavit.
Report that.
To that effect, we
My-
will file an affidavit, Lordship, regarding enforcement. Paragraph 3. Water body the plan.
PA petition is registered. This Suomoto PL petition is registered. Taking into consideration the issue regarding the encroachment over the Borosala beam situated in the midst of the city of Guwahati, which has already been declared as reserve wetland in 2001. Full stop. It is this court in 2001 in a PIL filed in year of, in the year 1997, has passed an order by giving direction to the respondents for preservation of bore solar wheel. Full stop. So to the direction given by this court, an affidavit is filed on behalf of the Guwahati Municipal Corporation,
Guwahati Metropolitan Development of.
GMD.
GMD, Guwahati Metropolitan Development Authority, wherein it is stated that the concerned bill is surrounded by the localities of Patan Bazaar and Patan Bazaar or north and Rehabari on east. Patan Bazaar on north, Rehabari on east, Chhatribari on west, and Chabipur on south. It is further stated that the untreated inflow of sewage water through various drains fall into the body, and due to the dumping of solid waste for surrounding areas in the beam, it has degraded the water body. It is further stated that the solar bill is part of Bharalu drainage basin, and the outfall of the bill is through the sluice gates located at the southern side of the bill, and thus the storm water is discharged in the Bharalu channel. It is also stated that the Pollution Control Board, as per the Pollution Control Board report, water quality of the Borsolo bill is contaminated with organic and inorganic substance. And the sewerage treatment plants on the upstream side of the water body has become defunct as the bed level, because the bed level as well as the water level has gone down below the intake point of STP, result in no flow with gravitation. Full stop. The said STP is non-functional since 2014. Is further mentioned in the affidavit that as per the NGT case, the Borsalo bill is considered as polluted water body, and it was considered priority first of polluted river stretches in India. And as per the NGT direction and action plan prepared by the Pollution Control Board, Assam, a project for construction of 2 MLD sewage treatment plant STP on the upstream side of Borosolo Bill with interception and diversion arrangement was initiated. The details regarding the same are mentioned in para 6 of the affidavit filed by the Guwahati Metropolitan Development Authority, which is reproduced here under. Full stop. Learned Advocate General has submitted that though 65% of 65% of the work of construction of two MLD sewerage treatment plants were, was completed on 15/5/2024. But today, the said work has completed up to 70%. Full stop. Para. Learned counsel for the petitioner has submitted that the the affidavit filed on behalf of the Guwahati Metropolitan Development Authority is silent about the encroachments made in the concerned bill area. At this stage, learned Advocate General has submitted that almost all of the encroachment from the concerned bill area has already been removed, except one garbage area, and for that, a suitable land is for that, the process for identification of a suitable land is going on, and soon it will be shifted from the bill area. Full stop. Taking into consideration the contents made in the affidavit of the Guwahati Metropolitan Development Authority in para 6 and the statement given by the learned counsel for learned Advocate General, we are of the view that the government, that the respondents are taking sufficient steps for preserving the Borosano bill. We hope and trust that the construction of the two MLD sewerage treatment plant would be completed within the time limit, that is of October 2024, and the state shall make every endeavor to keep the Borosal bill as encroachment free in future also. So with these observations, this PIL petition is disposed.
Deeply applied.
Item 6.
But,
Yes.
logic in this matter, for the respondents, my instruction was that the respondents have decided to approach the Honorable Apex Court. But they have already filed an SLP, and the status yesterday I got followed. Yesterday the case was listed and delay was condoned and dismissed. It was dismissed. I have the
Contempt, the SLP has been dismissed.
delay has been condoned and matter has been disposed of, dismissed. So now I prefer 3 weeks time. Let them come up with the. It was yesterday.
Why 3 weeks? What are those directions? What are those directions? The appeal deserves to be accepted, the impunity is reversed, and consequence speaking order set aside. As there is a plan to have been granted benefit of land to even they are drawing minimum pay scale shall also be announced in accordance with the pay scale the pending is approved to the plan from the date of review.
Look, question of some financial benefit is there.
Financial, how much burden is there?
That I don't know.
Few thousands of rupees, not much.
Ultimately, some decision has to be taken at the highest level. Logic.
When the division bench judgment is of 3rd of May 2023,
Logic.
your SLP has been dismissed. Why 3 weeks?
It is, the order has come yesterday. Well, I have downloaded from the net on 23rd.
It is informed that against the order dated 3rd of May 2023 passed by this court in writ appeal number 175/2022. The special leave petition preferred on behalf of the state has been dismissed on 23/7/2024. Learned counsel appearing for the, Mr. Deenath, learned counsel appearing for the respondent, contender, has submitted that in view of the fact that the SLP has already been dismissed against the order passed by the passed by this court, which has not been complied with, no option is left with the respondents except to comply with the direction given by this court. He pays 3 weeks time to submit the compliance report before this court. Just after 3 weeks.
Item 7.
As per the office.
My lord, in this matter, my lord, I am appearing for the sole respondent, my lord. I'll be filing my wakalat today.
You are appealing for
Sole respondent, my lord.
fourth respondent.
Yes, there is only one respondent, my lord.
There is only one sole respondent.
Yes, my lord, sole respondent. My lord, we have complied with the order, my lord. So I would like to file an affidavit in this regard, my lord.
You inform them whether they have complied with the order or not.
I have not received any communication, my lord.
What's the compliance order? Show us.
My lord, I'm just letting you know.
You already complied with them. Then we will
Consultation
go on this matter.
Consultation kori ami already khadi position there is an anomaly.
এটি কি লাস্ট অফ দিন
In consumer consultation,
Discussion is direct the Khadi board to refer the matter.
My lord, last
Consultation with the security.
সেক্রেটারি কে ডিরেকশন লব দিছিল ডিসিশন লব দিছিল
নাই বুঝাম লব দিয়া নাই কনসালটেশন করি পেলাই
উই আর বাই ডাইরেক্ট রেফার ফর্ম ডিরেকশন দিলে
কোন বড় নিয়ে গম
রেফার করে দিছিল
আমি ফাইনিং পালো is observed that the customer pays calcul কিবা আছে there was error apparent খালি ভুল করেছে এর কারণে কারেকশন করবার কারণে আমি কারেকশন দিলাম
কিন্তু আলটিমেটলি ডিসিশন রেফার ম্যাটার টু টেক এ ডিসিশন টু সেক্রেটারি দিছে না
সেক্রেটারি ইন কনসালটেশন উইথ বাদছে না
এটা ডিসিশন টু কি হয়
একটু দেখেন দেখে
কনসালটেশন উইথ দ্য ডিপার্টমেন্ট অফ পার্সোনেল ডিপার্টমেন্ট আৰু খাদি বডি ডিসকাশন কৰি
নাই নাই পাৰ্চনেল বোৰ্ড আৰু কিবা কৰিব সেক্ৰেটাৰী হেণ্ডল কৰিব কৰি পেলাই আমি আমি ফাইনিং
মাইনিউট চেঞ্জ
এইটো মাইনৰ ওপৰত ৰিকমেণ্ডেশ্যন কৰিব না আমি আমি করছি যে তোমার দিব লাগে এর অ্যাপারেন্ট আমি করব না এই যে কিছু অবজার্ভ করতে পেস স্কেল অফ সুপারিনটেন্ডেন্ট therefore it appears that certain facts and case structure of superintendent and assistant superintendent were not taken into account during DPC তোমার দিয়া নাই এইটো কাৰণে কারেক্টলি
hence the meeting will come on
the review DPC কৰিব কাৰণে DPC কৰিব লাগিব না review DPC meeting will be held by the some Khadi board immediately এটা হৈ গৈছে for consideration of the promotion তোমাক promotion দিব দিল
প্ৰমোশন দিব দিয়া নাই ওপৰত কি লিখিছে এনমলি হোৱা বুলি কোৱা নাই
কিন্তু এবাৰ one year starting fact structure were not taken into account
যদি কথাখিনি লিখিছে সেইখানে গোটেই ডিফাৰেন্স
Yes, what remains now?
Well, direction was issued to the secretary of the Khadi board to in consultation with the personnel departments.
We direct the Khadi board to refer the matter respective to Superintendent of Handloom, Textile and Sericulture Department.
Yes,
The controversy shall be examined by the Secretary of the Department in consultation with the Department of Personnel of Government of Assam. So now they have considered it, sir,
Yes, my lord. And we have recommended, we have given a recommendation
for review DPC.
review DPC, my lord.
yes, my lord. But I have not received any.
This is the order, man.
Yes.
What remains to keep, why to keep this,
I'll let it pending, my lord, after 2 weeks. We, in the
for
meantime,
what?
for final promotion, my lord.
Ultimately, if the decision goes against you, you can very well file again approach this court, otherwise
I
that
have
liberty
already
is
read
already there.
Yes, ma'am. I have already retired from service. I have not received any benefit.
Maybe you can, if they are, suppose if they don't give you the promotion or whatever, maybe you can very well challenge this again before this court. Okay. Then counsel appealing for the respondent, the sole respondent. And Mr. So-and-so is appearing on behalf of the sole respondent. Service is therefore complete. When counsel for the respondent has submitted that the directions given by this court wide order dated 28/8/2023, passed in writ appeal number 282/2023 regarding referring the matter for promotion of the petitioner promotion of the petitioner as Superintendent of Handloom, Textile and Sericulture Department. क्या लिखा है? एक मिनट और, सर। For promotion of the petitioner to the Superintendent of Handloom, Textile and Sericulture Department has already been complied with, and further, the Secretary of Department in consultation with the Secretary of Department of Personnel Government of Assam in their meeting dated 25th of June 2024 has recommended for a review DPC to be held by the Assam Khadi and Village Industries Board. Full stop. And the council has submitted that in view of the above, the directions given by this court in the above referred order has already been complied. A copy of the minutes of the meeting held in the presence of Secretary of the Handloom, Textile and Sericulture Department and the Secretary of Government of Assam Personnel Department has been placed on record. Let's stop. Then it counsel for the petitioner is not in dispute to, is not in position to dispute the above fact. In such circumstances, we are of in such circumstances, when substantial compliance of the order passed by this court has already been done, no further order is required to be passed in this contempt petition. The minutes of the meeting along with the forwarding letter be placed on, is taken on record. The contempt petition disposed of, notices discharge.
Deeply obliged, my lord.
Item number 8.
May I please, Lordship? So, as per office note 19/7/2024, my lord, service is awaited upon respondent.
Still, service has not been complete.
Not completed.
Await return of notice of sole respondent for 4 weeks.
Password meter 4.
Yes,
My lord, Mr. NJ Khatanir is not available today, my lord, and his name is also not shown in the cause list.
name is not shown. What do you mean by name is not shown? Last time he appeared. The case. When council has submitted that Mr. Patnaik is not available today due to some personal difficulty. Just after a week, while showing name of Mr. Patnaik as counsel for the respondent.
Item 9 and 10.
Well, we have received the affidavit filed by my friend. In this case, my lord, we filed the application, my lord, praying for time. Since
Extension of
initially only 2 years were granted, my lord, and my lord, in the year 2014.
2014, that 2 years and almost 10 years have already
No, my
passed.
lord,
Now, what extension of time?
My lord, subsequently, we filed affidavit showing that we never, my lord, there was no latches in our, on our part, my lord, because we were always in, taking up the matter, my lord, with the central government, particularly MORTH, my lord, which remained silent for quite a long time.
And why you are taking up the matter with the more? And the direction of this court is
My
not.
lord, we were without fund, my lord. The state government was without fund, my lord. And it was, the terrain was quite difficult, my lord.
Can't be the excuse.
It was an existing road.
Actually, they have raised a grievance regarding the, this.
My lord, their grievance is not the completion in time or, and their grievance is, my lord, reduction in the size of the width of the road. Because the more, the wider the road is, the more compensation they get. Not all people have come, my lord.
It's a petition, not
My lord,
an indeed.
the client of my learned friend, my lord, is not even, was not even a writ petitioner in this PIL, my lord. This is on record, my lord.
Ultimately, if the larger issue is involved, we will take into consideration. The essential, this grievance raised in the, this PIL petition is that despite the direction by this court in the year 2015 to complete the construction of the road within the 2 years.
My lord.
The road has not been completed, the construction has not been completed.
Now
And
85%.
You have changed the, whatever the.
Dimensions.
Dimensions from 4 lane or 3 lane to 2 lane.
From 2 lane to single lane, my lord.
Single lane.
Because it is not possible, my lord, on technical grounds, which we have explained in our affidavit in the.
What is the response of the MORT?
My lord.
MORT, what is the response?
Now
of the
it is
MORT?
going on as per the MOT, my lord, under its supervision. My lord.
My lordship,
MOT
may I-
has MOT has under its scheme of one-time improvement, my lord, has granted fund and under which the work is going on, my lord. Now your lordship will also agree, my lord, the summertime, my lord, the rainy season, it's difficult for the, in Arunachal, my lord.
Is almost 6 months.
Arunachal, my lord. 85, but last time we were before this court, my lord, the, our instruction 61, but now it is 85%, my lord.
Okay, single lane road, you may complete the instructions within few months. But
Right.
what about this changing the dimension?
My lord, this is as per the MOT's recommendations, my lord. We didn't do it, my lord. But that we explained in our affidavit. Para 3, and this is in line with the stand we have taken in the PIL itself, my lord, in para 8 of the affidavit filed by the MOT.
That has been taken into consideration by the, at that time by the judge.
My lord, it is quoted, my lord, the stand that para 8 is quoted in the order passed in the PIL, final order. That your lordship will find, my lord. in our affidavit at page.
Just a minute. This order passed in the PIL, well, earlier PIL 2014, and that is on 18/9/2014. Essentially, the PIL was filed,
No, this PIL was 101 of 2013, my lord.
decided on 18/9/2014.
Oh, yes, my lord. Yes.
In that PIL, the grievance was that they have changed the plan regarding the construction of the road.
My lord.
And the court found that, okay, it's, there is no malafide behind that.
Para 9.
And a direction is issued that as per that change plan,
My
to
lord.
construct the road within a period of 2 years.
My lord.
Now, again, you have changed the plan or what?
No,
you
no,
have
no,
done?
no, 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 no.
That-
Only issue is that this time, my lord, that we have gone, my lord, we have gone beyond the timeline set by the court, my lord. And there was no application file or review, my lord, seeking extra time, my lord. That was not done earlier, my lord. Only when the matter was brought before this court, then we filed this application.
So now you're supposed to complete the construction of the road by when?
My lord, we want to complete right now, my lord. It is raining, my
Want to
lord.
complete me.
My lord,
When
till
you are going to
September, my lord,
complete,
till
You
September, my
want to
lord.
complete overnight, but it is not possible. When you are going. to-
This winter season, it will be complete.
Hmm?
This winter season, my lord. After the
Season, what do you
stopping
mean
of
by
the,
winter season, some time limit, which month, which date, which year?
by December, my lord, 31st December.
December, sir, 2 years. time
My lord,
was
because
there.
right now, my lord, work is not going on, my lord, because of rain. And
How much work is complete?
85%, my lord, the instructions. Latest,
Sir, just a minute, let us,
85%.
85% to you as per this
From the
stand
department,
of the department.
Yes.
85% work is complete.
my lord,
Okay, and now up to December, you will complete the whole road, the
my
project.
lord, my lord. Because, the first application we had written, my lord, subject to the weather conditions, we had written there, my lord. We know how things proceed there.
Yes, sir. Yes,
Your lordship, there are so many incorrect statements that please excuse me if I miss responding to some. First incorrect statement, we were not a party in the PIL 10. Your lordship, your lordship, I am not going to make any statement which
Sir,
is superfluous.
we have already ignored that. It's a.
No,
matter
but
of
your
public
lordship,
importance
your
and
lordship,
if
it may
any
be very
person who was
relevant.
Not at all party has raised this point, certainly will consider it.
Your lordship, kindly hear me. It may be very relevant for your lordship's adjudication of this matter.
I see not a read petitioner, my lord.
There were two writ petitions, your lordship. They were
this.
merged and we were in the second one and we were made R11. Be that as may, your lordship, when we came here in contempt petition, your lordships, and we were not given the affidavit in this IA affidavit. I pleaded before your lordship that we have not received the affidavit. So what do we do? Your lordship in the contempt petition, now this is very important, your lordship. In the contempt petition made an order that we may be given a IA. Now, your lordship, why this is important? It's a procedural matter. Your lordship have all the power, but they refused to give us the IA and said you are not. Then we had to point out to them, no, we were R11. Now, the problem that arises, your lordship, is he has now given us the IA as R11. That will raise procedural issues of its own, which I leave to your lordship's discretion. Second point, your lordship. He says 85% road is complete. I raise two questions, your lordship. Road of what specifications and which road is complete? Your lordship, the tender against which we came to your lordship in contempt was merely 50% of the total road which was left out. The left out road was approximately 30 kilometers and the portion on which they had started, including the PMJSY2 and considering, was just 15 kilometers. Now, if 85% of 15 kilometers is complete, I leave it to your lordship to see there is another 15 kilometers. Now, this is as to what is complete. Second, what is the specification? Your lordship, the question here really is that what holds the field here? Does the order of Honorable High Court in PIL 101 of 2013 given in September of 2014 hold the field? because that order was based on two things, your lordship. One, my learned friend has brought out very clearly, the other they have missed. One thing was the state of Arunachal was supporting initially the petitioners, the PIL petitioners, in that the road must follow the old alignment. And they made submissions to North also accordingly.
Yeah.
In fact, the contract was signed with the original alignment.
Without?
With the original alignment.
Okay, fine.
Then the contractor even
he-
submitted
He submitted that this.
on the original alignment. No. One thing he submit that later. Later he submitted that there is a better alignment available. Let me do 15 kilometers instead of 30. And the national government, central government found that to be a good idea, which both of them reiterated. And at that time, your lordship, the state government of Arunachal took an interesting stand and said that, and the document we are producing here was produced there also, of 2013 May, I think, which said that we have given compensation on the new alignment. Now, this is the second point they are missing, which was argued in 101. In a very erudite manner, the Honorable High Court, without going into that controversy, has mentioned that since so much money has been received, because they tried to divert that money to the new alignment. Honorable Court held that this 49 crore, whatever has been received for the old alignment, you have acquired the land 20 to 24 meters across for making it a two-lane highway to national highway standards. So, your lordship, the expectation of the people is that a highway is coming up, which is two-lane of national highway standard. The diverted portion is part of NHAI project. This part is part of state project. Now, one more thing happened here, which is again anomalous, your lordship. Instead of the two-lane highway, they reduced it to that half portion PMGSY2. Now, your lordship, I humbly submit, if you see the PM, I have submitted, it's on file, I'm sure your lordship have, the way your lordship have, I'm sure you have seen it. PMGSY2 does not allow this highway, this road to be taken up for upgradation for two reasons. Number one, it has been upgraded on the strength of an MLA's complaint that the road is lying disused and unmaintained. Your lordship, the MLA has written that. Based on that, they have taken it into PMGSY. PMGSY2 clearly specified that any unmaintained road cannot be taken. Number one. Number two, the width of the original BRO road was 4.9 meters. Your lordship, I have shown from literature, they have come and brought a 2022 technical classification of Director General Border Roads of 2022. A lordship, the first one was made in 1960. Every year or 2 years, it is upgraded. In 1991, your lordship, what happened is, BRO roads are always, your lordship, being slightly away from what are the specifications of Indian Road Congress. 1913 Indian Road Congress were being followed everywhere, but border roads are following their own classification. I have in my pleading shown the border roads classification came from general staff roads, that is the military demand, and they were based on a very interesting requirement that one tonner was class 9, Jeep was class 5, and based on the vehicle. Now, lordship, these continued till 1991. I have enclosed in 91, the classification which they have quoted of 22 came and said that we must conform to National Road Congress standards. And therefore, in future, they made a new classification called class 5 bracket N and class 9 bracket N. That means new classification. Lordship, my learned friends are trying to confuse the court by producing new classification and their specifications, which are much lower. And this is admitted in 1991 classification, which I have attached and quoted. Lordship, I have a humble submission. In fact, there are three parts to it. Number one, your lordship, in all sincerity, it is my duty to inform your lordship that as far as this application is concerned, to reopen the matter in 101, this honorable court is functus officio in the matter.
We are not about reopening.
No,
It's
I
simply-
understand. So lordship,
we are-
in case, lordship, lordship, I'm not daring to comment on what your lordship is doing because I don't know. Lordship, I'm not daring to go in that direction. I'm merely pointing out to your lordship that as I have now received the papers as R11 and I have filed my counter affidavit as R11, there are implications of that. And as I look at it, if there is any order in this matter, and I'll go second step I will take, the basic roadblock is that this honorable court is functus officio because there has been, the lordship may not know, but there was an appeal in this matter filed by us in Supreme Court. And the Supreme Court said, what is your problem? You are getting a road. And it was dismissed. I was present, your lordship.
We are also saying this,
So, your lordship,
that we are.
your lordship,
just-
I could.
Just
yeah.
that if we are granting them time for construction of the road, then who is going to object it?
I'm saying, sir, your lordship, I said three parts. I may kindly be indulged, your lordship. Point number two, your lordship. If this honorable court gives them simpliciter time.
Yeah.
Simpliciter time, then the problem is, it is giving them a license, simpliciter time, your lordship, I'll come to the third part. Then they are getting a license to have evaded the constraints of the 101 PIL order. Right, your lordship?
Obviously.
So, your lordship, instead of making a two-lane highway, now the solution lies, your lordship, and our contempt will also be satisfied in perhaps your lordship. I have no idea what your lordship is going to do, your lordship. I'm merely presenting the three
Still,
possibilities.
we have also not made up any idea.
That's why I would say I'm merely,
We are hearing you.
yeah, your lordship, please don't think I'm trying to. The third possibility, as it appears to me, your lordship, is that first of all, additional time is part of this only submission. Additional time is not really required because the other alignment, that is the new alignment, they completed in February 2018. They never asked for time. There were multiple writ petitions on that matter. Time was never asked for. And so time, nobody has come for the time issue per se alone. It's also the question of specification of the road. The road specification that is to be made, whether it is done in 1 year or 2 years, must be of National Highway two-lane standard, which is 7.5 meters, your lordship. That's point number A in point number 3. The second point, your lordship, is, this is important, this is where actually the whole problem arises from. They have received monies for land acquisition in this area, which money has either been misapplied or God knows what has happened to it. That money has been partially distributed as per my client's information, and some people have not received anything, including my client. Now, your lordship, if they go, this is where the rest of the author of the whole problem arises, your lordship, as per my understanding, that this money is the core problem, and the honorable court in its erudite manner has incorporated this in the order, that this has been received. The real problem, your lordship, this money was given by Morse. Actually, the state has to use this money, or maybe 50% of this, to compensate people on the new alignment. This mismatch is where they don't want to discuss this money. The new road will require some investment, but already the technical feasibility was done by the contractor. He found a better way of doing it, fine. But he did give a line drawing with the feasibility. So that's not a question. The question really, your lordship, is, does EIL 101 hold the ground as per law of the land? It has not been reviewed. It has not been appealed against. There is no factual error in it which requires to be rectified. And your lordship, with this, I would like to conclude my submission without having referred to any document. If your lordships are not convinced, I would like the opportunity to.
Not a matter of,
Because I can take you through each and every document and prove my point, your lordship.
Contempt petition. This reply has been filed in contempt. petition.
Contempt pleadings are complete, your lordship.
Pleadings are complete.
In fact, after pleadings were complete, they filed this IJ.
Now, here today, that application, what we feel, subject to your arguments, we are going to grant them time. But so far as regarding this contempt petition is concerned, that will remain pending and that would be decided on its own merit.
Much
Without
obliged.
there being, without there being any interference, simply we are granting time, that doesn't mean that your contempt petition, you are absolved from the contempt. Unless we are satisfied, this is what we propose.
And your lordship, I humbly submit that the granting time may be for implementing the mandate of PIL 10.
Obviously,
Lordship,
this is what is their prayer in this?
Lordship, they are trying to get time for
Sir, what is their prayer in
for
that?
this PMGSY affair.
Sir, please, that altogether different matter, we'll consider it and if they have deviated from that.
Yeah.
Now, what is the application says? Sir? This interrogatory application.
Fifth, 2024, madam, prayer is
Lordship, the
page
application.
20, page 20.
Suppose it PAL so and so, permission of the view of the above and consider the course of argument. As follows. The affidavit was filed by the, we clarify the. The total length of the road is, Mr.
My lord, the map is there, my lord, it's
Lordship,
6 point,
the road for which the PIL was filed, the total length of the
31 kilometers.
31 kilometers.
31 kilometers.
And this contract is for 15 kilometers.
Now come to your prayer for extension of time.
My lord.
Basically admit the application for the please to extend the time and construction of the road from Nepua to Cheda 9.10 and Pijaro to VO 6.25.
My lord, because this is where the construction is yet to be completed, my lord.
And what about the other,
That is completed.
that has already been
Yes, yes.
completed?
Okay.
Six. Yeah, here,
Your lordship.
why you have mentioned regarding this only?
My lord.
You should have said it.
No, my lord, why this has had to be mentioned, my lord? Your lordship will see the original road was Sedi to Tapoyar, my lord, a very long stretch of road which was abandoned at a point called Pijiriang, my lord. Then this diversion was made, my lord, because some villagers from the other end had come down near the distance Arunachal highway, which has been completed. So that is the reason why this deviation has taken place from the original stretch to a shorter stretch.
That is, we are not concerned. That deviation has already been approved by the division.
Yes, my lord, MRT.
That's we are not concerned.
Yes, my lord.
We are simply concerned with that, whatever the direction given by the division bench.
My lord.
You are seeking time, what we now understand that you are seeking time
Right.
only
Yes,
to comply with those directions of the
Exactly.
year 2014 and not anything else.
my lord. My lord, I have to admit, my lord, this application for extension of time was never resorted to earlier.
Whatever it may be,
My-
that would not absolve you from this contempt proceedings. That
Your lordship is
we made
keeping the contempt proceeding pending, so.
we'll make it clear.
My lord. My lord.
Application is filed on behalf of the state of Arunachal. You are from the state of Arunachal,
My lord.
seeking extension of time for completion of construction of the road. From Sipa to Itanagar.
No. Lordship, it's referred to in all legal documents at the old BRO bypass section. Old
Exact-
BRO
what are-
bypass.
What are the exact?
Your lordship, I give you the exact.
Yellow.
What is the exact?
I'm giving you. Lordship. Lordship, there are two parts of it for the exact. One is the part for which they passed the tender where they are building, and there is another 15 kilometers which is left. So the first part, the 31 kilometers exactly
Sir, you
Sede
just
to
show-
Pakru.
You just show from this order. of
I am
2000
lordship.
2014, where is the description of the road is?
My lord.
Sede to Pakru, I'm sorry, Your Chair.
2014 order.
I'll look it up, Your Lordship. I don't think that is there in the order, Your Lordship, exactly the way Your Lordship is expecting, but I'll show you.
Para 5. Let's put hold. Let's put hold.
Your Lordship, if you see para second in the order,
Just
para 2 of the order, may I read?
Let's put hold. Julius, Kilometer, 15 or 16, है ना? 15 and 16. 16 kilometer to do what? এটা এবারও নেই। Kilometer to know. Isn't it? It was 15 or 25. I don't know, application of 3. কত করেছে? যেহেতু এই তো হয়, এই তো রাস্তা হয়ে যায়, এই তো রাস্তা থাকিলে এটা 15 কিলোমিটার হয়ে যায়, এটা 16 কিলোমিটার আছিল, এই 16 কিলোমিটারকে এটা 15 কিলোমিটার ওই বাদ দিলেন, এটা বাদ দিলেন, এটা 16 কিলোমিটার,
Earlier it was Sede to Itanagar, now it is Sede,
Lordship,
Sede
Lordship.
to Pakro.
Lordship, may I say to Park Royal Lordship, para 2 and para 4. If you will allow me to assist your Lordship,
I have.
para 2 says Sede to Park Road, 31 kilometers. Para 4 again says Sede to Park Road. Now, between Sede to Park Road, there is a third station, PG rank. So 31 kilometers is Sede to Park Road. Old alignment, new alignment is 15.4 kilometers. Now the old alignment 31 kilometers, they are building PMGSY road on half of it. Sede to Pijirang.
Yes, yes, madam.
And Pijirang
If
to,
I may clarify, madam, on this matter. Originally 31 kilometers, madam, from Sedi to Pijirang and then Pijirang to Pakro, my lord.
yes.
Now, what had happened, my lord, Sidi to Pakro made already a different road is made, that is Trans Arunachal Highway. So the old road, out of this 31 kilometer, 15 kilometer was done, Sidi to Pijirang, this is 15 kilometers. This was done by the PMGSY constructed, completed. Now another 16 kilometer remained, Pijirang to Pakro. This was bypass. Then what they did, my lord, Pijirang to VO. VO is on the national highway. Now that stretch is 6.25 kilometers. So 15 plus 6.25 kilometers.
The direction for completion of road, this PIL,
Madam.
from where to where?
My lord, initially Sedi to Pakro.
Sede to Pakro.
Yes.
This was the road which you have to construct,
Yes, madam.
that's all.
Yes.
And
Now,
for
Sedi to-
that,
now-
for
now-
that 2 years time was granted to you.
My lord.
That is what we will simply say.
Yes, 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 because the content matter will be there, my lord, these things will be clarified.
Yes. From CDSEDDE to Pakro in the state of Arunachal, for which this court granted 2 years of time to the state of Arunachal and other respondents, wide order dated 18/9/2014, passed in PIL number 101/2013. Full step. Admittedly, the above referred road admittedly, the construction of the above referred road has not been completed within the time granted by this court, and in relation to that, a contempt petition number 458/2020 have been filed by some of the petitioners, and the same is pending consideration. It is also to be noticed that till filing of the instant application, no such application has ever been filed either on behalf of the state of Arunachal or on behalf of any other respondents seeking extension of time for completion of the construction of the aforesaid road. Full stop. Learned counsel appearing for the state of Arunachal has submitted that due to certain difficulties and contingencies, which has been elaborated in the application for extension of time, the completion of the road from CD to Pakro could not be completed as per the direction given by this court in its order dated 18/9/2014. Full stop. Be that as it may, 2014, full stop. Learned counsel for state of Arunachal has further submitted that the up to how much kitna complete
85%.
up to 85% of the construction of the said road is completed, and for remaining construction of the and for the remaining part of the road, some more time is needed. Full stop. He has submitted that due to ongoing monsoon season, it would be difficult to complete the construction of the road, and therefore completion of the road, however, has gave a positive statement that the said road, the construction of the said road would be completed by December 2024.
My lord,
December
my lord, may I
2024.
just, subject to weather conditions,
So what do you mean by weather condition?
my lord.
Whereas weather condition, now monsoon is there, then what happened? What do you mean by weather condition? Get it completed
Yes,
by
yes.
2024. Now, don't take
No,
these
my lord, we
shifting
have
steps.
not left any stone
Weather
unturned.
conditions, so weather conditions would not be used for from again 10 years.
Hopefully from
You are
September,
not
my lord, we
going to
can
do that
resume
anything.
work.
For
September,
10 years, you can very well make an excuse of weather condition, weather condition.
well, I'll
What is
complain.
this?
I'll definitely.
No, this is not permissible.
Right.
By December 2024. Stop. The contentions raised by the council for the state of Arunachal in support of the application for extension of time. It's been highly, is being strenuously opposed by the council, appearing for the non-applicant number,
11, your lordship.
non-applicant number 11. And it is submitted that as a matter of fact, the state is not constructing the whole portion of the Sado Park Road approved road, but the construction is only going on 15 kilometer, on a 15 kilometer stretch. Full stop.
Single,
And that too, a single lane, on the basis of single lane. Full stop. It is also submitted that the reasons for non-completion of the, for non-construction of the road, aforesaid road are highly questionable and incorrect too. Full stop. Having gone through the application for extension of time and the affidavit in opposition filed on behalf of the respondent, number 11, we feel that prima facie, the state of Arunachal has failed to comply with the directions given by this court in its order dated 18/9/2014 for construction of the aforesaid road within 2 years. Full stop. However, looking to the interest of the public at large, we deem it appropriate to grant time to the state of Arunachal and other respondents to complete the construction of the aforementioned road by the end of December 2024. So we made it clear that this order will not affect the merits of the contempt case number 458/2020 preferred on behalf of some of the petitioners, and the said contempt petition would be decided on its own merit. It is also made clear that if the construction of the aforesaid road is not completed by December 2024, the respondents would be liable for contempt of this order also. Now do it.
Right.
This order also, with these observations, this IA number 875/2000, observation and directions. This IA number 875/2024 is disposed of.
Lordship, one small clarification, just for my understanding. The contempt petition, sorry.
Yeah.
Your lordship, I just wanted a clarification. Will the contempt petition await listing till December, your lordship, or will it be heard before that?
Listed after 3 weeks or 4 weeks.
Your lordship, as your lordship, I'm okay either way.
It can be listed after this December also.
Lordship,
So-
whatever your lordship
Let it come
decides,
to
I have
December,
brought
man.
this up because it may be a relevant issue.
List this contempt petition. In December also, suppose if they fail to comply with this order also, then again.
Further.
Lordship, I just, since if it comes up now, they may have a reasonable defense, your lordship,
Again.
that we are doing something.
Yes. List this.
So
contempt
after
petition.
December, your lordship, January,
List-
we can
list
keep it
this
in
contempt
Jan.
petition in January 2025.
Much obliged,
Much
Lord. Sorry, your lordship, for the, I was just trying to help.
That's okay.
Much
Item-
obliged, your lordship.
Item 11.
My lord, in this
case, we are appearing as legal aid counsel.
Sir,
My lord,
steps
we-
for,
my
steps
lord-
for service upon the respondent has not been taken, sir.
My lord, we are extremely sorry, my lord, we could not take steps, my lord, within the time, my lord, that has been
So
directed.
will,
2 days time may be allowed to.
okay,
my lord.
this court-wide order dated 27/5/2024 granted time has issued notices to the,
My lord, only 7 is private respondent, my lord, others are government.
yes, who is appearing for on behalf of all the other
I'm for
respondents?
my lord 2, 3 and 6.
What about one?
One is also, my lord, state of Assam, my lord. 1 to 6, in fact, my lord, they all are, my lord, under the government of Assam.
Not Development Authority.
No, my lord, represented by security to the government of Assam. Security of what department? Who is the chief secretary? If it is chief secretary, I can appear.
Why don't you file requisites for all the respondents, we'll consider it. File requisites for all the respondents.
My lord,
This court by order dated 27/5/2024 granted, has issued notices to the respondents. However, it appears that requisites could not be filed and therefore notices could not be issued. The net consent for the applicant prays for and granted 1 week time to file the requisites. On filing of the same, let notices be issued to the respondents returnable on current registered date.
obliged, my lord.
Item 12.
Yes,
May I please, Lord? This IF for confirmation of delay of 69 days, lordship.
why delay?
My lord, 69 days, lordship. That I have explained in paragraph 3, lordship. Similar case, lordship, that was listed on slide, and in that case, your lordship has issued notice.
Similar case.
Similar case, both the requisitions, so dispose of on the together,
Is there any merit in this appeal?
my lord.
On merits,
My lord, on merits, lordship,
you have a good case.
my lord, I think, my
Sure.
lord, my lord,
Every advocate says so. Should not returnable on current. So
obliged.
Item 13.
yes,
It is a lordship. This is an I for condonation of delay of 8 days.
what is there on merit?
There is merit in the matter, your lordship.
Yeah. Feel them.
Thank you.
notice of the I number so and so returnable of so and so.
Item 14.
May I please, your lordship?
Yes,
My lord, this is a condonation petition, first time has come before your lordship.
443
Because my lord, due to communication gap with them, my lord,
communication gap with whom?
my lord, they are my lord, retired college principal, lecturer, my lord, 78 years old, my lord, they are.
So what relief they are asking for?
Well, actually, they are, my lord, they are not given due to misunderstanding of gratuity and leave encashment, my lord. Otherwise, they are getting all other pension benefit, my lord. As per rule, my lord, they are entitled.
The communication gap in respect of the material instructions or what?
Yes, my lord, I have stated, my lord, paragraph 8, my lord, of the application.
Yes. What do you want to say?
Notice will go, my lord, private respondent is one.
Yeah.
College is there, my lord.
Yes,
My lord, respondent number 5, my lord, notice will go, my lord. Otherwise also, my lord, there is no proper.
principal, Kokrajhar Government
Yes, my
College.
lord. Otherwise, there is no proper explanation of, my lord, communication gap, my lord.
What is there on merit?
Sorry, my lord.
Merit,
Uh,
merit of the case.
My lord, we have filed in our, filed affidavit, my lord, in the merit 75, my lord.
Actually, my lord, may I state, my lord,
Notice, Mr. So and so accept notice on behalf of the respondent number 1 to 4.
I will be appearing for 1 and 2, my lord.
And what about 3? Accountant General. So and so for respondent number 1, 2, 3 and 4, get the presence mark. Let notice be issued to the respondent number 6 returnable on so and so.
Absolutely.
Yes.
diploma.
For admission, item 15.
Lordship, nothing survives. We have reinstated her, Lordship.
Reinstated when?
Long time back, Lordship. Now a fresh petition is pending. We are filing affidavit there also.
Uh, The parties are in agreement that pursuant to the order passed by this court on so and so which date?
It was 18th of June 2024. She was reinstated.
18th of June 2024. This order of the division bench or single bench.
Oh,
Pursuant to the orders passed by this court, the petitioner or who has been the respondent Monsoon
Borka Koti.
Walker Koti have already been reinstated in the service. Stop. In view of the fact that the respondent has already been reinstated in service, no further order is required to be passed in this contempt petition as well in this writ appeal as well as, or what is this?
Contempt case number 260.
Contempt application as well as in contempt appeal.
260/2023.
230.
260.
260 of 2023. Hence, this contempt application number so and so as well as the contempt petition number so and so stands closed. Notice is discharged.
Obliged.
Item 16.
May please your lordship. My lord, this PIL is preferred lordship by the petitioner. Lordship, the fact of the case is that lordship, since last few years, lordship,
Anybody is appearing on behalf of the state?
My lord, I am appearing for respondent number 1, 3, 5, 6, 7, and 8.
Where is that NIT?
NIT at page 47, Lordship,
47.
the last NIT. Lordship.
So here, there is no mention that only the persons who are running the industry can submit their bid, or any other person, any individual can file a bid.
Sorry, Lordship.
Your grievance is that these areca nuts are not good for human consumption. And while auctioning or issuing that NIT, there is no mention that it can only be used for industrial purpose and not for the human consumption.
Lordship, my contention is only that, Lordship, if the industrial wear is only allowed, Lordship, because
But that only for this NIT should be confined to those industries.
Yes,
and
Lordship,
not
that-
to the general public.
yes, Lordship, because otherwise it will be sold in the open market, Lordship, which is more dangerous for human life, Lordship.
Okay, why this PIL? The petitioner has raised the grievance that the state as well as the state authorities, including the police authorities, have seized areca nuts from various individuals from time to time, and those seized areca nuts are put to auction for the public at large. It is contended that those areca nuts are not fit for human consumption, and from where we got this is not fit for human consumption.
Lordship, the main fact is basically, Lordship, areca nuts are agri products, Lordship. So after keeping it storage for 2 to 3 months, Lordship, it will obviously unfit for human consumption. But
For
in
human
the
consumption.
NIT itself, it was mentioned, Lordship.
Where is that?
Yes, Lordship, that I may read it, Lordship. In persons of the so and so, affixed with court fee, only are invited from the interested buyers party for sale of areca nuts within bracket not fit for human consumption.
क्या लिखा है? As evident from the NIT issued by the Superintendent of Police Silchar on 12th of July 2024 in bracket Annexure 7. Full stop. And council has submitted that, taking into consideration the fact that the seized areca nuts are not fit for human consumption, the NIT should only allow the persons operating the various industries to submit their bid and not any individual, because there is all possibility that those purchased areca nuts through the NIT may sold to the traders who may use that seized areca nuts for making the products consumed by the public at large. Full stop. Issue notice.
May I point out one thing, my lord? My lord, for lordship may kindly peruse the my lord, condition number 14.
Yeah.
The bottom of
What is
the NIT, page 47.
Yeah.
The successful bidder has to deposit court affidavit citing therein that the seized areca nuts will not be used for human consumption and will be used as raw materials for other industrial purpose before lifting the.
File your affidavit. Issue notice. Mr. Swan, so accept notice on behalf of the state.
1, 3, 5, 6, 7, and 8, my lord.
That
My
notice
learned
is
friend.
issued And you are appearing,
Agriculture department.
all this notices are served?
My lord.
Mr. So-and-so is appearing on so-and-so and Mr. So-and-so is appearing on behalf of so-and-so. Writ petition is supplied or copy of the writ petition is already in, supplied
No,
to you?
no, that is required to be served, my lord.
The copy of the writ petition. is
Extra copy, I
supplied
will
To the council for the respondents, but during the course of the day, the respondents may file their response to the writ petition after, within a period of, by the next date of hearing, list after 4 weeks.
My lord, as on 26 lordship, that NIT will be finalized lordship, and there is a huge quantity lordship.
We'll see to it.
So that has not,
We will not say the process of an item. We'll see to it, any further future directions that to be granted.
Item 17.
May it please your lordship. My lord, as per the last order dated 27/6/24, my lord. Notice of motion was issued. My lord, we have taken steps. However, my lord, there are 24 private respondents. Their
Have,
service is
not
not
been
completed,
served.
my lord. Yes, my lord.
And in fact, you have filed the amended cost title.
Yes, my lord.
Only on 19/7/2024. Therefore, only the notices have been issued on that date.
Yes, my lord.
So there is a delay on your part.
Yes.
Take care. As per the office report, as the amended quarter, the cost title was filed only on 19/7/2024. The notices to the, notices to the respondents number 4 to 18 and 20 to 28 has already have been issued only on 19/7/2024. Let notice issued to the above referred respondents be awaited for 4 more weeks.
Obliged.
For 6 more weeks.
Item 18.
Well, this is a matter of grave importance for the simple reason that this matter will hinge on the entire reservation policy in the state of Assam is a subject matter of this litigation. My lord, what has happened? The original, there is a checkered history to this case.
Yes.
My lord, what has happened in terms of the 85th Amendment of the Constitution, the Parliament overruled the Mandal Commission's case, which said that there won't be reservation in promotion, and it was given effect from 17/6/95. And naturally, yes, can I start?
Yes.
Naturally, the law laid down with the Supreme Court was that reservation, the roster, as soon as accelerated promotion is given, there is no doubt about it that consequential seniority will not be an additional benefit, it will be a consequence. So that has been the law followed throughout the country. In Assam, we have the 78 Act, which provides for accelerated promotion and consequential seniority. One of the first round of litigation came in the year 2016, when the government of Assam.
You are aggrieved by a particular notification. which
Yes,
the
my lord,
learned
my lord.
single judge, which has
My lord,
learned single judge. has
learned single
concluded
judge-
that, in fact, it is.
My lord, the
only-
learned single judge went in my favor, saying that the 2002 is holding the field. You cannot deny the benefit of merit, because merit, when we go on merit, we go as a member of unreserved class. We don't go as.
Favor than by
Then
your
this was upheld by the division bench in the IB Gohai's case.
Fine.
And what has happened, then the Assam government came up with an OM whereby it basically diluted the effect of the Bhagwan Pata's judgment and brought in a catch-up principle which is unheard of. Now, the learned single judge, this OM of 18 January 2023, we challenged it on the ground that it goes not only against the judgments of the Supreme Court, there were 2 judgments of the Guwahati High Court delivered by single judge, and the division bench judgment in IV Gohai confirmed by your lordship in the Equality Forum judgment. Now, the learned single judge, what he did, he basically made a finding that there is, in the 78 Act, there is no mention of any consequential seniority, oblivious of the fact
that in the Indra Swani's case by the 9-member bench of the Supreme Court, the Supreme Court says that the government need not come up with a rule. Through executive instruction and OM, they can give the benefits of 16.4.
Let's response of this.
Well, Lord, only one thing I like to say, my Lord, this matter, the entire DPCs will be now holding in terms of the single judge's order. My Lord, the chaos will be there that the Supreme Court has said that you cannot take groups. You have to be cadre wise. And the learned single judge has diluted that by saying that it will be group wise.
We'll see.
So at least some protection, my Lord,
Protection is always there, sir. If the writ petition, this appeal is pending, that there is no need to say whatever the exercise to be carried by the
That will
state
be
government,
there.
that would be subject to the
Yes, my
petition.
Lord. But at
That's not, there is no, why you are seeking this innocuous order?
no, well, I'm seeking for the simple reason that the Supreme Court's order, the division bench order and the single bench's order go counter to the single bench order of the
That we
court.
will examine,
Yes.
but simply at this stage, interim stay order.
Yes, ma'am.
no.
Well,
Yeah, you
Lordship
should
will
notice-
specify that.
you should, there's no need to clarify it even, sir. Once we are issuing notices, then the matter is sub judice, then whatever the process they will do, it is
It will be
sustaining, sir, subject to that. Issue notice, yes.
I am appearing for response number 1, 2, and 4.
Issue notice, Mr. So notice on behalf of the respondent number 1 to 4. Let notices be issued to the, there are so many writ petitions and the appeal is in. Writ petition.
Yes, my Lord, because the others have already retired.
So the writ petition, this writ appeal is challenging the which
Order of the single judge, Lordship.
in past date writ petition number.
Yes, Lordship. WPC. Well, it was one judgment which covered the entire case. Well, I'm giving the judgment order. Well, it is writ petition 363. That is the primary case.
363. And you are the petitioner.
In-
You are the petitioner.
Well, I'm in 828. 828.
Then
The learned single judge took one case and laid down the law. The primary case is 363.
how many respondents are there in?
Well, respondents 20. 50. 15 respondents. Minus 15 or minus 10. There are 15 respondents.
Mr. So-and-so put in appearance on behalf of so-and-so respondents. Issue notice. Mr. So-and-so accept notices on behalf of so-and-so. Let notices be issued to the other respondents of the, of this writ appeal returnable on when? 4 weeks. Renewable after 4 weeks, requisites to be filed within a period of 3 days. Registered any district. Sir.
Obliged. Obliged.
Item 19.
Noble single judge matter without considering my rights and entitlement under the 19th.
So the learned single judge has simply said on the second verification, you are not found to be disabled,
Yes,
suffering from a particular degree of disability, then certainly it is open for them.
yes, my lord. But even my lord, even assuming my lord, I am not, I have not the benchmark disability, my lord.
Yeah.
Then also, my lord, I have a right to but the reasonable accommodation under section 3, my lord, of the 2016 Act. And also, my lord, under the OM
Reasonable accommodation means what?
means, my lord, it's a means to achieve the substantive equality, my lord. The persons, because my lord, right has been given the equality and non-discrimination on the ground of disability, my lord. And my lord, and in the OM, my lord, though under the Act, my lord, says that the reservation for the PWD and the concept of benchmark disability has been introduced in the Act, my lord, to identify the post and reserve the post for the category of persons, my lord. 5 categories are there, my lord. And but for the reservation is for the PWD and that should be horizontal, my lord. But my lord, under the OM, my lord, the government of Assam issued an OM, my lord. In the OM, my lord, the government says that the reservation for the 4% reservation for the benchmark disability, my lord. But in the, my lord, there is a relaxation clause, my lord. It reduced, my lord, clause 4 and clause 11, my lord. In that says, my lord, the person with benchmark disability who are selected without relaxation, my lord, they will be adjusted, my lord, general quota. And my lord, yes, my lord. And my lord, and persons, and there is a relaxation of for the persons belonging to the category of my specified disability, my lord. They are entitled for relaxation, my lord. That is the concept of reasonable accommodation.
Sir, the question is that the persons who can get the benefit of this reservation for the benchmark, persons with disability should be suffering from a particular degree of disability. Otherwise, any person having minor or whatever it may be, or not up to that degree of disability cannot seek appointment on the post reserved for that, sir.
My lord, they can, my lord.
They can, how can it be, sir?
Yes, my lord. Kindly see, my lord, if your lordship kindly see 2016 Act, my lord.
Yeah.
2016 Act.
So any person, irrespective of degree of disability, is
Yes.
required to be adjusted against the post
Yes.
reserved for that.
Yes, my lord.
Ah,
My lord.
how can it?
Kindly see section 3, my lord.
Section 3.
My lord. Equality and non-dis.
Yeah.
Yes, madam. Equality and non-discrimination. The appropriate government shall ensure that the person with disabilities enjoy the right to equality, life with dignity, and respect for his or her integrity equally with others. The appropriate government shall take a step to utilize the capacity of person with disabilities by providing appropriate environment. No person with disability shall be discriminated on the ground of disability unless it is shown that the impugned act or omission is appropriate, proportionate means of achieving a legitimate aim. No person shall be deprived of his her personal liberty only on the ground of disability. The appropriate government shall take necessary steps to ensure reasonable accommodation for persons with disability. Then, my lord, kindly see section 20, my lord. Section 20, my lord. Non-discrimination in employment, my lord. No government establishment shall discriminate against any person with disability in any matter relating to employment, provided that the appropriate government may, having regard to the type of work carried on in any establishment by notification and subject to such condition, if any, examine any establishment from the provision of this section, my lord. My lord, then, my lord, if your lordship.
Please now come to the definition of person with benchmark disability.
Yes, my lord.
Who are?
Yes. My lord, persons with benchmark disability means a persons not less than 40% of a
specified disability.
Yes, my lord. But you kindly see section 34, 33 and 34, my lord. The reservation clause, my lord. 33, my lord, section. Section 33, my lord. Identification of posts for reservation.
Yeah.
The appropriate government shall identify posts in establishment which can be held by respective category of persons with benchmark disability in respect of the vacancy reserved in accordance with the provisions of section 34.
Yeah.
Then, my lord, then subject constitute an expert committee, so my lord, then section 34, my lord, reservation.
Yeah.
In every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre stand in each group of posts meant to be filled with persons with benchmark disability, of which 1% each shall be reserved for persons with benchmark disabilities under clause A, B, C, and 1% for persons with benchmark disability under clause D and E, namely so and so, my lord. Then, my lord, clause 2, my lord. Clause 2. Where in any recruitment year, any vacancy cannot be filled up due to non-availability of a suitable person with benchmark disability, or for any other sufficient reasons, my lord, such vacancy shall be carried forward in the succeeding recruitment year. And if in the succeeding recruitment year also suitable persons with benchmark is not available, it may first be filled by interchanging among the 5 categories, and only when there is no person with disability, my lord, available for the post in that year, the employer shall fill up the vacancy by appointment of a person other than a person with disability, my lord. So, my lord, person with disability, they can be appointed.
How can it be, sir?
My lord, kindly,
What is this interpretation?
my lord, kindly see rule 11, my lord.
Yeah.
Kindly see rule 11.
Rule 11, yeah. Sir, this means other than the person with disability means the person, it can be filled by general person without any disability, having no disability.
Now, person with disability, my lord, he says, it says the person.
Other than the person with disability, other than, read, other than a person with disability.
My lord, then, and my lord, then, just before my lord, and only when there is no person with disability, my lord, available. If person with disability is not available. And kindly see my rule 11, my lord.
Rule 11, yeah.
Rule 11, sub rule 2, my lord. Rule 11, my lord.
Yeah.
My lord, subclause 3, my lord, if I see my lord. My lord, while making advertisements to fill a vacancy, every government estimate shall indicate the number of vacancies reserved for each class of persons with benchmark disability in accordance with the provision of the section 34 of the Act. My lord, fourth, then, the reservation for person with disabilities, my lord, in accordance with the provision of section 34 of the Act, shall be horizontal, my lord. Yes, but person with disability, my lord, not person with benchmark disability, my lord. And my lord, and the vacancy for person with benchmark disabilities shall be maintained as a separate class, my lord.
So what about this reservation to the persons with the benchmark disability?
My lord, the Act says every government shall appoint not less than 4%, my lord, not less than 4%. That is, my lord, it should be, my lord, it may be above 4%, my lord.
That is that there, sir. But in your case, the second assessment,
Yes.
you will not find this. You were not having that degree of disability. This which entitles you to come within the definition of person with the benchmark disability.
No, my lord, benchmark disability is only for the identification of a post, my lord.
No.
And my lord, in
Sir,
OM, even.
the person's reservation provision itself is there, reserved for the person with the benchmark disability.
Then your lordship, kindly see the OM, my lord, 106, my lord, page.
Sir, what to do with the OA when this act specifically says?
When the Act says, my lord,
Every appropriate government shall appoint in every government not less than 4% of
Yes.
cadre instance each group meant for the person with the benchmark disabilities.
Then, my lord, kindly see close 11, my lord.
11, what do you mean? 11 of what?
11 of OM, my lord.
OA?
So close OM, my lord.
Yes. Where is that OA?
Page 106, my lord.
06.
Yes. When rule 11 says, my lord, the reservation for PWD, person with benchmark, person with disability, my lord, is.
Which clause?
My lord.
Clause?
Close, first we see, my lord, close to 4, my lord. Adjustment against unreserved post, my lord.
4.
4, plus 4, then 11, my lord.
Clause 4, yes.
Yes. In the category of posts which are identified suitable for person with benchmark disabilities, a person with benchmark disability cannot be denied the right to compete for appointment by direct recruitment, promotion against unreserved post. Thus, a person with benchmark disability can be appointed by direct recruitment, promotion against post not exclusively reserved for person with benchmark disabilities, provided that the post is identified suitable for person with benchmark disability of the relevant category. Then, my lord, 4.2, my lord, person with benchmark disability selected without relaxed standards along with other candidates will not be adjusted against the reserved share of post, that is a 4%, my lord. The reserve post will be filled up separately from amongst the eligible candidates with benchmark disability, which will thus comprise of candidates with benchmark disability who are lower in merit than the last candidate in merit list, but otherwise suitable for appointment if necessary by relaxed standard. Then your lordship, kindly see clause 11, my lord. Then kindly see clause 11, my lord. Clause 11. Clause 11, my lord.
Yeah.
If sufficient number of candidates with benchmark disabilities are not available on the basis of the general standard to fill all the posts reserved for them, candidates belonging to this category may be selected on relaxed standard to fill up the remaining posts reserved for them, provided that they are not found unfit for such post. However, my lord, these provisions shall not be used to allow any relaxation in the eligibility criteria laid down for the issuance of certificate of disability, my lord. The eligibility, what is the eligibility criteria for issuance of certificate, my lord?
Sir, first of all, is sufficient number of candidates are not available with benchmark disabilities are not available. You have to show in your case, the vacancies are lying vacant.
Yes.
Apart from that, even though we agree, but we have doubt that we'll agree with you.
Yes.
Apart from that, in your case, the vacancies are lying vacant and the persons with benchmark disabilities are not available.
Yes, because my lord, the OM says only 4% they have reserved for benchmark disability.
Yeah.
Yes, my lord. Only the 4% person has been selected, my lord. Only 4%. By conducting the reassess, my lord, they have selected, they have to pick up the only the benchmark disability. So 4%, if the 50% out, my lord, they are not benchmark. The 4% reservation is available vacant, my lord, because only the 4% candidate, PWD candidate has been selected from the competition, my lord. Therefore, not less than 4%, my lord.
Yes.
Therefore, my lord, section 34 says that not less than 4% every of the government, my lord. So, and the OM formulated, my lord, only for the 4% reservation for the benchmark disability. But the OM given the benchmark disability person an extra right to compete the general post, my lord. That right cannot be denied because they are
Who appeared before the learned single judge?
Yes, my lord.
Who appeared before the learned single judge for the writ appellant?
I am, my lord.
So you have not raised any such ground before the learned single judge.
Because, my lord, in motion, my lord, I was.
So what do you mean by motion, sir? You should have argued all these things. You have not argued a single, what we are arguing, what you are arguing here.
But
not a single submission is there.
My lord, one judgment of the Honorable Appellate Court was placed by in another case. I was not aware, but the state of UP, my lord, that judgment, I was not aware. That judgment.
You are not aware of what?
My lord, judgment of the Appellate Court.
Judgment of the aware, there is, it is not a document created by the respondent. The judgment is always there. And everybody should know about the judgment.
But
it is expected.
But in the concept of thought, that is in the judgment, my lord.
Sir,
that is.
Mr. Advocate, what you are arguing here, you have not argued a single point before the learned single judge. So how now you can raise all these points? If you would have raised those arguments, learned single judge will pass some judgment on that. Or if the learned single judge missed it, file a review petition. Even though if you have raised and not considered, file a review petition. Here, Mr. S.K. Roy.
Yes, my lord.
Mr. Roy, what you are arguing here, not reflected from this order, sir, that you have even argued before the learned single judge. And apparently, sir, these Yes.
So my lord, post are there, my lord, and even my section 34, my lord. That is reservation and read with my lord, rule 18, my lord,
Yes.
my lord. The reservation for my lord PWD, my lord.
Fine.
That is horizontal. And if my lord,
Yes.
and there is post available, my lord. And my lord, if your lordship allow me, allow me to file review, my lord.
Fine, we are not allowed. It's up to you. There is no question of allow or not allow. Yes.
Lordship, there is
You are
no,
appearing in this.
Lordship,
You, Advocate General is appearing in this.
the issue is, Lordship, no, there are a series of cases. This is not a single case. So these cases in our favor, the other cases are pending, number one. Number two, he has also requested for keeping one post vacant of the subsequent vacancies which have arisen, where recruitment process has started, 5,000. That shows that there is no vacancy.
My lord.
And when he has 14%, when the requirement is 40%, absolutely, Lordship, all these arguments will not hold the field.
Yeah, what do you want?
My lord.
What do you want?
My-
What
Notice.
do you want then?
My lord,
Order on merit? Or you want to approach the learned single judge with all your arguments which
My
you are raising here?
Honorable Singh adjustment. Honorable Singh adjustment.
He wants to withdraw. No?
Wants to withdraw with liberty to file review application in accordance with law.
Highly obliged.
And my lord, there is a limitation, my lord, the review petition, my lord.
File an application, review application, limitation, the non-single judge will take care of that and the judgment is recent.
Yes, my lord. Please.
Then there is the question of limitation file.
Obligement.
And that is to be considered by the,
Yes.
yes, next.
Deeply.
Item 20.
Yes.
Maybe the this appeal deferred against the order dated 21/6/2024, wherein the learned single judge held that the director, the limitation department to give the charge to the headmaster of the instance to S1 of 5 losses.
So she was senior, she is senior as per the date of birth.
But as per date of birth, but we have not,
Why both of you were services of both of you, the appellant as well as the respondent were provincialized on the same day.
Same day, lordship.
So regarding the seniority, the date of birth would certainly relevant for that purpose.
But I am not a what is the date of birth, lordship, because in 6
You are?
lordship, in 6/40, no notice has been issued, lordship. The petition filed by the S1 of 5 lordship, the petition.
Sir, even though if the notice is filed, what do you have said whether she is senior as per the date of birth or not?
Date of birth is not in the.
So the learned single is just taken into consideration.
Only held that, but on that day, the state respondent is supposed to file the affidavit lawsuit to bring on record the entire.
The petitioners in both these petitions, having been provincialized in their services on the same
Yeah,
date
that-
on,
that is true.
that is on 16/5/2023, that is from 11/13. It is now to be seen who amongst them would rank senior for the purpose of holding the charge of post of headmaster of said school. The
Lordship,
petitioner, having been provincialized in the service under so and so, the entry of the government son would be treated point of row so and so, applying their respective date of birth.
Date of birth.
Applying the dates of birth as available on record, it is seen that the petitioner in that petition number is senior to the petitioner so and so.
Lordship, the
You are disputing this fact or not?
I am disputing, lordship, disputed because I am in P545 lordship. In my case, I am Isra score as it passed in favor of me. I am holding the charge of the headmaster lordship.
Sir, you are holding the headmaster as per the rules. The person who is senior is required to hold the charge of the headmaster.
Lordship.
And the petitioner has challenged that this petitioner in the writ petition number 6943 has challenged that illegally you have been assigned with the charge of the post of headmaster, though she is senior. Then one order was issued for directing you to hand over the charge, against which you have also filed a petition. Now the learned single judge has disposed of both the petitions while holding that since the petitioner in 6943 is senior, she is entitled to hold the post of this. What's wrong in that?
Lordship, as per notification dated 2/10, 2010, a district level committee should be constituted. The district level
So
committee.
that is in charge post of headmaster, not regular post headmaster. And the learned single judge is again said regular basis. Headmaster said school till the post of headmaster is so filed by the regular basis. That's all. Nothing. That's all. The writ appeal is filed. This writ appeal is filed by the petitioner being appellant being agreed with the order dated 21st of June 2024 passed in writ petition number 6943 oblique 2020 through 23, as well as writ petition number 3545 oblique 2023. Full stop. The dispute before the learned single judge regarding the regarding the holding of the charge of the postmaster, charge of the post of the headmaster of the school concerned. Full stop. The appellant and the private respondent herein were claiming that they are suitable for assigning the charge of the postmaster, post of headmaster of the said school. Learned single judge has taken into consideration the fact that both of the that the appellant as well as the private respondents that the services of the appellant as well as the private respondents were provincialized on 6/5/2023, that is from 1/1/2013, 1/1/2020, sorry, 6/5/2013, that is from 1/1/2013. And as per the provisions of Assam Venture educational institutions in bracket provincialization of service, provincialization of services, bracket close, Act 2011, their entry into the service would now be treated as the point from where the seniority would be considered. It is further observed that other factors being same in respect of both the persons, their inter se seniority can now be determined only by applying their respective date of birth. Full stop. The learned single judges concluded that the private respondent who has filed writ petition number 6943/2023 is senior to the appellant, and therefore a direction is issued that the private respondent shall hold the charge of the post of headmaster of the said school till the said post of headmaster is so filled on regular basis. Having heard the learned counsel for the appellant, and after going through the material available on record and taking into consideration the dispute raised before the learned single judge, we don't find any case for interference, and this appeal is dismissed. Yes. Mr. Advocate General, you are in this next matter.
Next matter, Lordship.
Yes, would you,
Next matter, we have some recent developments. We'd like to file a short.
what about that memorandum?
Yes, it has been
MOU?
signed. That we want to bring on record.
MOU with the ITI,
Yes, Lordship. We want to bring on record. That is the affidavit which is required, Lordship.
how much time?
1 week.
Yes,
Yes. Let them furnish a copy, man.
10 days.
Lordship. Highly obliged, Lordship.
Item 24. Last location also. I'm on behalf of 1 and 2. Memo of appeal is also yet to be served on us, my lord. After delay has been condoned.
Yeah,
After delay has been condoned, memo of appeal has not been served. The last occasion also petitioner didn't appear.
the copy of the appeal is not in receipt.
Not has been served on us. Neither to us, neither to the education department.
None appears for the appellant. Is notice that appeared also on 25/6/2024, none has appeared. However, in the interest of justice, this after 2 weeks.
Item 25.
May I please, your lordship? Can this matter kindly be taken some other day, lordship?
But yeah,
Obliged, your lord.
Item 26.
Your lordship, I'm appealing for respondent number 7 and 8, lordship. 10 days time may be given to file affidavit, lordship.
yes. We are seeking time.
Lorships, in the meantime, the impugned judgment may be stayed, lordship. There is a while issuing notice.
Impugned judgment is dated.
Impugned judgment is dated, that is at page lordship 21. Dated 9/10/2023. While issuing notice, this one constantly stated that.
9/10/2023, almost 8 months have passed. Now what?
Lordship, in the note.
Having heard the respondent number 7 and 8, place some time to file counter to the writ appeal. What happened to the original writ?
That is pending, lordship. Because of
So dates.
Item 27.
May I please, Lordship? In this case, my lord, I have communicated the copy, my lord, but I have not received any instruction. May I pray, my lord, some more time to respond, my.
You are appealing in person.
I am, yes, petitioner in person.
Let them file their response. Why they have left out to you some category of persons. Okay, Mr. So-and-so. Depending on behalf of the state of Assam, seek some more time to file counter to the petition. Seek some time to file counter to the petition. In fact, earlier, no one has appeared on behalf.
Lordship, I have
On 2 occasions, no one has appeared. Take some time to file. A reply to that, counter to the PIL petition, time for is not 4 weeks.
Lordship, I have a small prayer that since I'm appearing as a petitioner in person,
my name does not reflect. That is why I could not appear on last occasion. I overlooked the cause list. Date not
Petitioner in
fixed.
person is written here in the cause list.
Normally I search by my name.
Majumdar, this likha hua hai.
It is the petition, my lord,
Okay,
when
This one so and so after showing name of petitioner in person. In the name of cause, in the cause list.
Lordship, date may be fixed, Lordship.
Date, whatever, 4 weeks, after 4 weeks, whatever the date.
Item 28.
In this case, though I have received instruction from respondent 910. From the respondent number 8, it's still awaited. Can I pray for some more time, my lord, to file our response in the case, ma'am?
Lord, actually, what happened, I'm appearing on behalf of Anita HCL, with the current. Because the large, honorable single judge is not paid only that to go for a particular, because he got some amount. Another amount is lying with the office, that which point of that, he wants some more amount, that is arbitrator only can be decided. That we see, he decided, and not the government. Anyhow, he's praying for time and I don't have anything.
Let us see. Council appearing for the respondent number 8 and 9.
8, 9, 10, my lord.
8, 9, 10, place some more time to file response to the writ appeal.
Let,
So and so,
let it be up to 3 weeks, my lord. In 3 weeks, sir.
3 weeks.
Item 29.
Lordship, I appear online, my lord, for item number 29, my lord.
Yes.
This petition is filed under GST, my lord, and notice was issued to the respondents for their reply, my lord. Reply is yet to be filed. And consideration of my interim prayer is pending for. Yes, my lord.
He's coming, he has got some instruction, my lord. In fact, there is some development in the budget, my lord. Probably
Yes, my lord.
will become infectious, my lord. He's
Yes, my
coming.
lord.
So this petition has become infectious or will wait for some time?
Not holistically, my lord. Major of the demand goes up with the proposal what is there in the budget finance act, finance bill, my lord.
Fine.
So this may be posted after a month. So by that time,
The amendments will come, my lord.
Okay. List after 4 weeks.
my lord, till then at least interim order may be given, my
Sir,
lord.
when the proposal is already there, who is going to realize the amount?
Yes.
Because an order is there, they may enforce it, my lord. That is only the apprehension.
Days till date this budget is passed, everything would be sorted out. 4 weeks.
Briefly applies.
Item 30 and 31.
Pursuant to the last order, I have got the instruction. My instruction says that.
Yeah.
That, my lord, minutes of meeting, my lord, this is not a cabinet decision. It was a minutes recorded between the, my lord, department and the, my lord, Karmasari Parisar. There this decision was taken. It has not been implemented.
Not been implemented, then once it is recommended by the High Court, why are not implementing?
No, it's not. No, only the honorable court only, my lord, asked me to have the instruction whether, my lord, case will be covered or not.
Regarding cabinet decision, it was not a cabinet.
It was not a cabinet decision. It was a minutes of a meeting, my lord, held between the Karmasari Parisar as well as the government.
And the government.
And the government.
So, principally, the government is agreeing for that.
That, my lord, they are saying they cannot, but they have, one thing they have stated, that, my lord, this issue can be decided only when the pay commission is constituted. Last pay commission was constituted in 2015. Every 10 years, my lord, after 10 years, it is to be constituted. So we are in the end of, my lord, 2024.
Why we wait for that?
Lordship will post it, my lord, next week, then we can go for hearing of the case, my lord.
We do it, whatever is needed.
Lordship.
Then council, Mr. B. Gogoi has submitted that as a matter of fact. The cabinet had not taken any decision to follow one pay for same and for same and similar works policy, and it was agreed between a meeting of the employees association vis-a-vis the finance department. Mr. Gokli, your pleadings are complete.
Yes, my lord, I filed my.
Pleadings are complete. In this matter, let this writ petition, writ petition is admitted, no need to issue notices, parties are already represented, let this matter for hearing in due course.
It was between the government and the, my lord, and the Karmasari Parishad, not with the finance department. Direct.
Government and the,
Yes.
this, instead of, finance department, government and
Yes.
Karamchari Parishad.
Item 32, my lord, instead of usual course, can there be a date, my lord? Otherwise,
So due course may you take the date from the registry, they'll give you the date.
deeply obliged.
It's a clear case of custodial death, the charge sheet will show 7 police persons,
Yes, may I please, my lord, on the last occasion, my lord, your lordship, my lord, directed. Proposal, my lord. The proposal is 5 lakhs, my lord, for full and final compensation, my lord.
Full and final compensation. File your affidavit, will decide it.
In the meantime, let them pay the amount, my lord, they are 2020, my lord. The lady, let them pay interim compensation.
Pay that 5,000, 5 lakhs.
His income was, my lord, 3 lakhs 15, my lord.
My lord, in that case, my lord, lordship may dispose of the matter, if my lord is direct.
Why to dispose of?
My lord.
5 lakh, you pay it.
My lord.
If she is entitled for more compensation, we'll pass an order. You pay the 5 lakhs.
In the said circumstances, may I pay, my lord, for an interim, 2.5 lakhs, my lord.
No, once you have decided 5 lakhs.
5 lakh is, my
give
lord,
her 5 lakhs.
full and final compensation, because, my lord, there are some direction from the National Human Rights Commission.
Sir, we'll consider that.
My lord.
We'll consider at the time of hearing.
And there are no
But
such,
let the compensation amount which the government has determined,
my lord.
that compensation amount be paid for. Okay. On 24/6/2024. The additional senior government advocate, Mr. R.K. Bora, was granted time to submit a positive proposal for granting full compensation, full and final compensation to the petitioner. And if not full compensation, at least the proposal for interim compensation is required to be placed before its court. Mr. R.K. Bora has submitted that the state government has decided to pay a compensation, full and final compensation to the tune of rupees 5 lakh to the petitioner. Full stop. The counsel for the petitioner has vehemently opposed, has submitted that in view of the fact that it is a clear case of custodial death, more compensation is required to be paid as per the various pronouncements of the Honorable Supreme Court in the matters of custodial death. Would stop. Having heard the learned counsel for the parties, and after going through the material available on record, we are of the view that the question regarding the entitlement of the petitioner for compensation over and above rupees 5 lakh, comma, as decided by the government is required to be considered finally. Hence, petition is admitted. No, but need to issue formal notice as parties are already represented. In the meantime, the state is directed to pay the compensation to the tune of rupees 5 lakhs to the petitioner, comma, as decided by the government, as per the decision of it, within a period of
4 weeks.
within a 4 weeks from today, it is made clear that the payment of the said compensation would remain subject to the final outcome of this petition.
Well, the payment may be put in the petitioner's bank account. Will provide the detail.
That will be done as per
Within a
procedure.
4 weeks, in the bank account of the petitioner, details of which would be, will be supplied by the counsel for the petitioner to the counsel for the state.
That will be.
My lord, instead of name of Mr. R.K. Bora, my name may be reflected, my lord. Take a Sharma, my
Okay.
my lord.
Yeah.
Obliged. Obliged.